Tight on time, so yeah, could you
No, I'll hand it.
You will hand it up. Yes, so there are handouts, there are tasks for you. Maybe now, yeah. It's something probably you should do at home rather than now, or you can do it along the way as I speak. But it's a test for you to test yourselves on what I'm going to talk about. If you're intelligent, probably you could also guess sometimes. Yes? It's just the most appropriate answer is correct, right? But probably you can either do it now and swap, and if you want to have grades, then someone will grade your colors. Or your mom at home, yes? Or husband, wife. So this is just instead of question and answer session, but I'm talking about mediation in civil and commercial matters compared to the Polish perspectives. I am a mediator, and this is not, I'm not going to read anything which I brought, but it's just to show you when you complete a course is to become a mediator, because I'm going to talk about that there are no formal requirements as to what profession you come from. And so you don't really have to be a lawyer even, or a psychologist for that matter, but that's what you get. Yes? And this is actually the entire training, yes, is in here. But I have to add that I did not have to complete. It's just complementary mediation, civil and commercial mediation, because I did not have to do the entire course, which is a little longer. Probably you would get twice as much materials, because I studied mediation and ADR and arbitration and other things in Ghent when I did my LLM. But so this is just to show you and to assess for you whether you think it's enough to be such a to do such a responsible thing. Okay, so what I wanted to talk about, but probably I will boil it down to or I will skip some issues, is definition, origin, and application of ADR as such, mediation compared to litigation and other methods, efficiency and justice, which is something I absolutely love, and I don't write anything without referring to law and economics in my research, and enforcement of the reached agreement. Then specific features such as phases of mediation or stages, mediators' tasks and duties, and quality of mediation, and some law, and some sources of law, but this is going to be just one slide, and the Polish perspective. Although this last thing is probably the most boring in terms of the implementation, because it's like, some articles from the Code of Civil Procedure, but and the quiz, which you have. So the definition, I borrowed one definition from a Center for Effective Dispute Resolution, which is a British one, I think, but there are many more globally. So, but I think this particular one is quite accurate. And there is also, since I'm talking about this directive 2008/52, this comes, the other one comes from this directive. Just one copy, but I can do it. If you're here, you don't see anything really.
And I see it as well.
Yeah. Right. So yeah, you can read it. I'm not going to repeat, but the main features in the first, I think the first definition is that it's flexible. I think it's different from the second. Whereas the directive speaks about a structured process, and of course it can be done on a voluntary basis, or it has to be done on a voluntary basis, but on the other hand, it can also be suggested or ordered by a court, which means that it's not so voluntary anymore, but on the other hand, when it comes to mediation, which is ordered by the court, you cannot force either party to do it, right? So if the parties don't agree, they don't want to reach an agreement, then then they will come back to litigation. And of course, it's done with the assistance of a mediator, which we're going to talk about later. Origin and applications. Basically, ADR stands for, you have it in your test, but I will help you, alternative dispute resolution, and basically the main feature of the whole bulk of methods is that it's alternative to what? What is the alternative to? Litigation, of course. So there are many divisions, since you can actually, many ways to divide ADR according to different standards. But one important is that you have criminal and civil mediation. Yes, so when it comes to mediation, it is criminal and civil mediation. Civil including family, commercial, and labor. And another division is that you can have, which I'm referring to Poland right now, especially that you can have pre-trial, ordered, or suggested mediation, which is suggested by the court, but also you can still do it if it's out of the party's own initiative. You can still do it when litigation is in place all along the way. And well, this is a lot of text, but this is basically something which you can also read when you Google my article, Mediation in Closed Circles. It's quite long, and the funny thing is that, well, I did not want to mediate with the Polish Center of Mediation, but what they did is, unfortunately, they published it without consulting me, and actually I filed it like 2 years before, and I said, okay, there are amendments to be made, because I had it in place even earlier. But if you are ready to publish it, then I can translate or not, yes, and just let me know. And they never did. And after a few months, like for example in April 2015, I came across my own article, which was never proofread by myself, right? So, and also there is one thing at the end, because everything is correct, and it's about history also of origins of ADR, so that's fine, it doesn't change. But the last sentence is that there is a proposal of a directive, and it is meaningful that there is a directive in place, right? So I didn't manage to change it. But well, it originates from access to justice movement in the United States, 1970s, and yes, and basically it's about the granting the possibility of a wide public to have this access to justice without necessarily paying a lot of money, without going through a lot of stress, etc. Right? So this is the idea. But in my article, which, like I said, you can read, and I invite you to download it. It's like open access. I talk about mediation in closed circles, or it's also called self-contained mediation. So we are here at the university, and this is one way to use mediation to avoid certain problems which might arise at universities between students and teachers, and between different stakeholders, right? But so this is one way to do this, and the other one is mediation in medical field, and here this would also be civil and commercial law as well, yeah? But not necessarily criminal, because it might concern overbilling, errors and omissions, employment, or medical malpractice. Right, but I don't have time to speak more about that. So also, in terms of features of mediation, I will come back to a list, but here is an excerpt, a short excerpt from my article, and you can see that it's very cheap, it's more focused on the parties and balancing their interests, rather than letting one prevail. And this is important because it is not a zero-sum game, thanks to mediation, when you have a conflict, right? The conflict you perceive normally as a zero-sum game. So if someone loses, someone wins. This is the case in court, always. There's never a chance that someone, probably even in most cases, both the parties will be dissatisfied with the outcome. Because one loses, obviously he or she is not satisfied, but the one who wins might also have some issues, right? So the only way to counteract this is to go to mediation. Mediators are not restricted by the law. They can have more flexible ideas and outcomes in the mediation settlement. It's based on fairness. Both parties present their reasons and their briefs, because many times the conflict is not really about what it looks like when you file a lawsuit, for example. It's a lot more behind the lawsuit, yes? It's like years of some problems arising, and you don't resolve it, you cannot resolve it in court. You only do it through mediation. So the mediator looks for all the ways to reconcile conflicting interests and has to facilitate communication, sometimes even threaten the parties a little bit by saying that litigation is a lot more costly and some colors have changed in here. So you have just a list. I'm not going to give you, even an idea of what each of them is. I'm going to speak only about mediation, but you can see, and this could be even longer, right? Arbitration, med-arb, so a combination of mediation, then arbitration, the other way around, etc., right? So ADR encompasses all those methods. I also wanted to talk about advantages and disadvantages of ADR as such, but some of those things I have already referred to, showing you the excerpt from my article. Advantages basically are that mediator is not necessarily a lawyer, right? So a judge is a lawyer. The doctrine of judicial precedent, I refer to the common law system here, will be applied, but in civil law, it will also be some legal certainty, which might be prevalent in court. There is an appeal system if a party is unhappy. This is very strict procedural rule. And legal aid is available for those on low income, whereas in ADR, especially in arbitration, you don't have legal aid because you have to pay the arbitrators their fees. And disadvantages of civil courts are that they are expensive because you not only count in the fees, court fees, but also the time. So, I mean, they're time consuming, but the time is money as well. So, there are delays, yes, lengthy proceedings, which end up in Strasbourg, for example, in the case of Poland, very frequently. Procedures are more complex. Courts also are open to public and press, and with respect to commercial proceedings especially, it's not something you want to do. And so you don't really want to reveal your problems, in your trade secrets as well. Yes? If there's a conflict between companies, then they might want to turn to something less open, yes, to the public. And also, for example, mediation, the outcome of mediation is never revealed to the public, right? So this is also secrecy. And likewise, arbitration is not all arbitral awards are published, and even if they are, it's very limited information. So, but the judge will not have technical expertise. Yes? So this is something which arbitrators and even mediators might have. For example, those who are psychologists might be able to communicate with the parties more effectively, efficiently. And the court service or the court chooses the trial date, whereas in mediation or ADR, as such, you are free to do it. I'm going to skip arbitration versus litigation comparison, yes, because this is not strictly the topic. But I'm just going to give you a hint about one economics of mediation, just very briefly. You have some strategies which you employ as a person, and especially during the situation of conflict with another person. And so those strategies can also be used in court, but in mediation they're probably even more evident. And also there are some reasons within game theory why mediation is better than litigation, and why some ways to mediate are better than others. I will just refer to one of the games you put first, and it's a game, it's a theoretical situation where two persons are put in prison. One is guilty, one not. One is like a psychopath, the other is not, is a very timid person. And let's say the prosecutor says, you stay in prison for 20 years, or as long as you agree on who is guilty. Yeah? So the person who confesses will get 5 years of imprisonment, and the one who does not will be set free. But guess who confesses more frequently? I mean, based on research and on empirical studies. The good one, yeah, the good guy, yes, or girl. Because, why? Because the bad guy just enjoys it, yeah? Enjoys his time in prison, and bullying the other person is especially good, right? So there's one reason why mediation lets you, in a way, it will let you be on equal footing with the other person, but only if this person is not a psychopath, right? If he is, then, for example, you would choose mediation which is indirect. So the mediator meets up with both parties or all parties separately, right? So this is also the reason behind it. And some psychological principles which are proposed, or I don't know if you've heard of Cialdini, but probably you have, yes, persuasion and making people do what you want was the topic of his books, has been. So you basically, your actions are based on the principle of reciprocity, and this is very important in mediation. Yes, you make contingencies. Yes, you agree to something when the other person does, right? So reciprocity is important. And for example, consensus. Yes, consensus because you prefer to do something which is also done by your peers. Yes, so and which is also, for example, advocated by some authority. So authority is also here. Consistency. You want to be consistent with something you have previously done. So also this is an explanation why mediation is very frequently more efficient than a judgment which has to be enforced, because parties tend to stick to their values and their decisions, yes, which they have made out of their own will, and this is done in mediation, not in court, right? So you don't really need enforcement very frequently because they will do as they promise. Oh, this is, and so I'm going to skip. And also, well, this is the last of the economics and psychology issues behind mediation and litigation and ways to mediate, because you have here a very evident clash between legal norms and social norms. And so something I have referred to before, legal norms are imposed on people by the court, yes, by the police, etc. Whereas social norms are something which you have inside, or it's done by your peers, by everyone else around, so that's why you want to follow. And that's why, because there can also be mediation which is out of court and which is non-binding even, right? And sometimes you want to have your agreement approved by the court, and then it becomes binding. So basically, gentle nudges, yes, is something more efficient, more effective than hard shows. Hard show, I would say that it's something done by the court. You are ordered to do something, yes? And gentle nudge is something the mediator has to do, yes? Just to kind of make you do something because you like it, because you want it, and because it's nice. Also when we refer to the Cialdini's 6 principles, the psychological ones. And the examples here are different, yes, but for example, Marmite, instead of, I don't know, placing a sanction on people who chew their gums and throw them away, you would rather install something like that on bus stops. Marmite, you love it or you hate it. Yes, you have to say that probably you actually do hate it most frequently, but sometimes you love it. Yes, and you prefer to do something which attracts you. You stick the gun rather than just throw it away. Yes, and you know it's for children. This thing here. And also, we all sort at Brussels airport is another example of showing that you should do something because it's better, yes, because we all do it. Okay, so now coming to the more strict issues and legal issues. When you look at it, there are stages of mediation which range from 4 to 8. Well, whenever in the literature, yes, you can have different levels of generalization. Yes. So this one is a very the one which is advocated by the European Union. It consists of 6 stages. Yes, this model, and it is the opening stage. It is the statement of the problem by the parties, right? So the mediator invites everyone and welcomes everyone. Then he invites people, the parties, to tell what the problems are. Then identification of the issues and determination of the agenda, because it also has to be timely, yes, and it has to be expedient, so the agenda is very important. Then the mediator tries to get the options, he tries to generate them, he tries to brainstorm the parties, yes, so they come up with options themselves, and then they consider the options and select the most workable solutions, and then the mediation ends with either reaching an agreement or no agreement. So, by doing so, or in the course of mediation, there are different tasks and duties, such as, well, some of them also, I'm not going to go into details here, but you might say that independence and impartiality is the same thing, but independence means from outer environment, and impartiality is your attitude towards parties. Disinterestedness, you should not be interested in the outcome. Neutrality, yes, you should not be biased towards one of the parties. Professionalism, also in drafting legally enforceable agreement. Competence, respect to the parties, and ideally a mediator should be somewhere in between a facilitating agent, so a passive mediator who says please rethink your positions, and a hyperactive one making proposals. Ideally it is in between. And quality of mediation, it should be fair. This is something which is also to be found in the preamble of the directive, right? So I'm not going to go through the preamble in detail because this is also in the preamble. Fairness, proper balance between necessary formalities and less stressful character. Expediency, as I said, cost effectiveness, it's relatively cheap. And it's also a form of restorative justice which serves better weaker parties. It has voluntary character, yes, and it's even stipulated very firmly in the Code of Civil Procedure. Acceptability of the person, of the mediator, for example, and of the outcome. Confidentiality is very important because there is even a case, there is even case law in the ECJ regarding that issue. And equality of the parties. There are sources of law, also just to look at them. International, you have model law. You have regional Council of Europe recommendations stemming from the 80s and then 2002. And you have the EU law, and there are more, yes, there are more. There's a directive on ADR, consumer disputes, and there's ODR, which means online dispute resolution in consumer disputes, but I'm only referring to the one which is binding, it's binding, but also it is only about civil and commercial matters. Yes, and aim of legislation is presented in the preamble, as I told you. Basically, it's the same as the quality of mediation, which I referred to previously. But the scope is limited to cross-border disputes only. Whereas when I refer to Poland right now, because I have like, how many minutes? 5? 10? Yeah, 10? Okay. So I will come back to Poland, but right now I can tell you that Poland has chosen, and actually it had been done before the term of the time for implementation has lapsed, because Poland introduced the law before. So like it was already in place in 2005 and 6 in the Code of Civil Procedure. But because we did it, there's no, well, also there's the principle of non-discrimination, yes, and the principle saying that you cannot have a worse position in a member state if you're a citizen of another member state procedurally, right? So also the procedural justice and equality. Therefore, there's no problem, the Commission sees no problem in the fact that member states may choose to implement the directive or to have some legislation in place which does not differentiate between cross-border disputes and purely national ones. Right? So this is applied to both in Poland, at least. But acts that are excluded from this directive are acta iure imperii. So where the parties have no, their rights and duties are not at their disposal, and this is how the directive refers to it. Right? So for example, administrative law, revenue, etc., will not be, tax law will not be within the scope. And also, the person of mediator is defined. The most important thing is that it has to be, he has to be impartial and competent. And there are problems with the latter, right? Because in fact, there are no strict rules so now I'm telling you that something which is not to be found in the directive about the minimum standards of their professional skills, right? So that's a problem. Maybe this is enough, right? Maybe, but maybe not. Maybe you should be required to repeat the trainings every now and then, right? Which you're not really, as a rule. Yes, but it depends on the mediating center. And of course, member states must ensure quality control mechanisms and training. Well, this is a general statement. I have to tell you that some of you are or have been my students and should know, at least I hope. And even though those who were not, should also know. I hope that directives just give the aim. Yes, I mean they state the aim to be achieved by the member states, leaving the methods to the member states, right, and the form. So some directives are more detailed, some are less, some norms would be directly effective, some not, right? But this is, well, I don't know, this norm should be regarded as directly effective. Member states must ensure quality control mechanisms. It's very general, right? So this directive, I would say, its main problem, but also the reason why Commission is still satisfied with its implementation, because it is, the Parliament is not, however, and I will come back to that, is that it's really quite general. Yes, it's quite general. Also, confidentiality is stipulated as one of the features, unless or except where this is necessary for overriding reasons of public policy. And I'm not going to read out loud, but you can read for yourselves what they might be. Or where disclosure of the content of the agreement resulting from mediation is necessary in order to implement this agreement, so this is quite logical. Enforceability, sorry, quite tricky. Also, member states should ensure the ways to make mediation agreements or settlements enforceable by courts, but this is also up to the national laws, how to do it. And there are some competent authorities, which also range, they depend on national law, but the list must be notified to the Commission and made public. And you can access it on the portal of the Commission and the portal where the information is provided on all member states, right? So you will know what the authorities are, which may issue also authentic instruments, not just judgments, not courts. So they don't necessarily have to be only courts. And this is quite important as well, and also it shows up in some judgments of the ECJ, some recent ones, relation to litigation and arbitration, so other proceedings. ADR is, arbitration is also a means of ADR, but litigation, of course, court proceedings. So the important thing is that parties are not subsequently prevented from initiating judicial proceedings or arbitration in relation to that dispute by the expiry of limitation or prescription periods during the mediation process. So it does not exclude other ways of dispute resolution. Roles of courts and sanctions are also provided for by the directive, but very generally. So member states are free, the directive says, to provide for incentives or sanctions to promote mediation, and it happens. It ranges from country to country, but some, for example, reimbursement of fees, yes, is one way to. Is it a hard shove or a gentle nudge? Reimbursement of fees. You don't go to mediate. You refuse mediation. In fact, you are now required by the law. Yes, if you have you file a lawsuit, and there are elements of the lawsuit which are necessary. Yes, so one of them is that you either agree or not agree to mediation. If not, then you state reasons why not. Okay, and it may affect you adversely at some point financially. This is basically the only way. Financial. So there is gratification if you come to mediation because your court fee will be reimbursed, for example, right? So this is one way to do this. You're not otherwise punished or sanctioned, but there are some more severe sanctions in place in some member states. And court may invite the parties to use mediation in order to settle the dispute. In Poland, you will see how it's done. It's not perfect, right? Because, for example, the court cannot do it throughout the proceedings. It may only do it until the first hearing is finished. Right? So, and then only if the parties decide of their own initiative that they can have recourse to mediation. Also, I've mentioned, and I'm finishing in 2 minutes, that the EU Commission has issued a report recently on implementation, because obviously in every directive you have the review mechanism as the Commission then gathers or collects the opinions of stakeholders and checks this implementation in all member states. So the Commission, this is not so important, but the difficulties identified were that, and this is not surprising, at least in Poland, I would say, lack of a mediation culture in member states. Yes, we have been a communist country where nobody trusted nobody else. Yes, I mean, there was distrust, there was fear, yes, and there was no mediation culture, to put it gently. Sanction was something which you would expect, rather than trying to deal with the problem between yourselves. Insufficient knowledge of how to deal with cross-border cases, and that's why the Commission advocates more information campaigns, etc. Training standards, codes of conduct. There is a European Code of Conduct, which is not non-binding, it's like a model law, but there is one for mediators. So obviously this is something which has to be done by member states, and it's not really sufficient. Cultural change is still necessary, and especially the parties, lawyers, and judges remain reluctant to refer parties to mediation, which is also connected with the lack of mediation culture. But generally, the Commission says that there's no need to review the directive. However, a year later, the Parliament said that there is a need to review it. And, for example, that there should be EU-wide quality standards for provision of services, that there should be registers of mediation proceedings, and information campaigns. I'm skipping now the case law, but it's just there. I'm not going to go through the facts and the judgment, but basically, in the first case, there was a constitutional court decision before, so the court decided, the ECJ, not to decide it. It was not necessary because some national provisions were already or had been declared invalid. And in the second case, there was a decision based on another directive, the one on consumer dispute resolution, but it was quite important that consumers should not be required to use advocates' services. Yes, where this requirement was in place in Italian law. So Italy should not do it, nor any other member state, right? Because this is not in line with the directive. And now the Polish perspective for just 1 minute. I told you that it's only about the civil procedure code, and I referred to Polish solutions all along the way. But basically, it's enacted in Articles 183, uppercase 1, which is like, well, how do you say it in English? Like the subsection? No, the znaczkiem. Index, exactly. Thank you. No, just kind of, I lost it. To 15, right? So it was kind of added inside the code, yes? And this is about mediation. So basically, once again, voluntary participation of parties is also based on Article 45 of the Constitution. Parties' agreement, mediation agreement, even if implied, is required. And if you have an agreement, there's also one important thing, that conclusion of such an agreement does not prevent the court from hearing the case in civil proceedings. If, however, the defendant raises the defense of concluding the mediation agreement, the court will refer the case to mediation proceedings back. And so this is quite important. And, well, there are some sanctions for unjustified refusal to participate in mediation. Well, there's one thing which I wanted to tell you about expediency. Yes, everything has to be done immediately in the proceedings. So a mediator is appointed immediately. He also must immediately notify the parties if he refuses mediation for some reason, because he sees no solution here. He also sets the date immediately and then files the report with the court. Also, approval of the mediation settlement, the mediation agreement should be done immediately by the court, if it's enforceable, of course. Well, and this is important. The last thing which I'm going to talk about from the Polish perspective is that mediation should be completed by 1 month, within 1 month. But on the other hand, if you have the 6 stages which you have to complete, sometimes it's not enough. But the parties can ask the court to extend. However, the court does not have to agree, yes, and it may turn out to be unfeasible. There's the e-justice portal, where all information can be obtained. So I refer you to that, yes, and also on the state of implementation of the directive in Poland. And the last thing I want to tell you, as legal practitioners now or in the future, especially, is something which Judge Posner has done. I think it's the only judicial decision, verdict in the world where he actually inserted, by the way, breaching copyright, which was raised by the ABA, the American Bar Association. He inserted pictures, which he found on some website. Yes? One of them is of the ostrich, and one is the attorney behaving like an ostrich. So the thing in Poland, and the problem in Poland and some other member states where there is lack of mediation culture, is that also the attorneys, the advocates, pretend that it does not exist. Yeah? Why is an open question. My idea is that maybe because they fear their fees will not be too high when mediation resolves the problem quite early on, right? So, but this is something to think about, right? So I personally advocate mediation from my own experience and as an academic, so this is what I wanted to convey, and thank you.